Hi, my name is Paul Goyette, and thank you for taking a look at my blog, paulgoyetteblog.com. What I'm going to talk about today, at this moment, is the George Zimmerman Trayvon Martin shooting and tragic death in Florida. Now, specifically, I'm going to talk about Florida's Stand Your Ground law. Now, when lawmakers in Florida passed Stand Your Ground, what they intended is they wanted to make it easier for citizens to defend themselves. What they really had in mind was they wanted to make it easier, cleaner, more streamlined for a homeowner to defend himself, more likely shoot and kill, a burglar that was entering his or her home. And they extended that to his or her car. Okay, that all sounds good, but it's not really working out as they intended. They really didn't think Stand Your Ground through very well. Because what they didn't anticipate is the biggest test of Stand Your Ground, which is the George Zimmerman Trayvon Martin shooting case. They didn't anticipate that Stand Your Ground would serve as the platform for a Hispanic neighborhood watch captain who gets into an argument, scuffle, disagreement of some kind with the African-American kid who lives in the neighborhood. They didn't anticipate that. What they were thinking is they were making it easier for a homeowner to shoot the burglar in the head who was coming through his window while he or she was home in the middle of the night. So what does Florida's Stand Your Ground say? Well, it's contained in Florida statutes section 776.013, and it basically provides as follows. First, that any person, if he or she has a reasonable fear for imminent peril of death or great bodily injury, may use force to defend himself. Now, that person is presumed to fear for his safety if the suspect was unlawfully entering a dwelling, residence, or vehicle, and the person using force had reason to believe an unlawful entry to one of those places had occurred or was occurring. Most importantly, Stand Your Ground says that the person using force has no duty to retreat. He or she can stand his ground, can meet force with force, including deadly force, to prevent death or great bodily injury. That's what the code says in Florida. So what Stand Your Ground basically says is that a citizen in Florida can use force, including deadly force, to defend himself or herself if he or she reasonably believes and fears for his safety or life. Now, that standard is remarkably similar to the standard that law enforcement officers are held to here in California, in fact, throughout the country. For police officers and other public safety officials who have the right to use force, including deadly force, they can use that force if they reasonably fear for their life or safety, or the life or safety of someone else. Now, that standard is judged objectively based on what the officer knew at the moment he used force. It's not to be viewed in hindsight with the benefit of 20/20 vision. It's what the officer knew at that point in time, what he perceived, what he saw, what he heard, what he smelled. All those factors taken into account objectively allows the officer to make the decision, should I use force, including deadly force, or not? It's a remarkably similar standard to Florida's Stand Your Ground. So Florida's Stand Your Ground is essentially the same standard that's applied to police officers. There's one big problem, though. Police officers go through extensive, exhaustive training before they are given a weapon and the legal right to use deadly force or force of any kind. Police officers here in California go through a police academy to start with that's many, many, many months long. It's an extremely exhaustive program, and they're trained extensively on when to use force, how to use force. Once they start working for a police agency, they have regular training, sometimes monthly training, sometimes weekly training, certainly annual training on how to use force, when to use force, what type of use of force tools are available, ranging from handguns and shotguns to tasers and batons. They're trained on all of that. Most importantly, police officers go through extensive background checks and psychological testing. If you fail your psych test, you can't be a police officer. You are never given the right to use force or deadly force. That's the big difference. George Zimmerman in Florida had none of those things. He had no training. He had no academy. But most importantly, he had no psychological testing. Is he psychologically suited to be able to make those difficult decisions in stressful, violent, quickly changing circumstances? Probably not. Law enforcement officers are trained and observed and trained and observed again to make sure they can make those decisions. George Zimmerman had nothing like that, or any other citizen, or most other citizens in Florida. So what Florida has done with Stand Your Ground is essentially given George Zimmerman the right to use force, including deadly force, access to the weapon, and essentially told him to go to work. The real problem with Florida's Stand Your Ground is lawmakers did not anticipate the consequences of this particular law. They didn't think it through very well. The problem with the Zimmerman Trayvon Martin case is that the application of Stand Your Ground is going to depend on almost an unlimited number of factual scenarios. And lawmakers didn't anticipate the unique and tragic factual scenario that came upon Mr. Zimmerman and Mr. Martin. In that sense, Mr. Zimmerman and Mr. Martin are both victims of Florida's Stand Your Ground.